So perhaps the most overused word in American politics right now is the word treason. But what exactly is treason and what does it mean? Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. If you share my concerns, maybe you could like this video and subscribe to this channel, maybe even click that little bell that'll notify you when I post something new. So this is a video that I'm making specifically at the request of my wife, who thought that we should probably delve a little bit into exactly what treason is, because you hear about it all the time. People accuse each other of being treasonous, but what exactly is treason? Well, treason is actually one of the very few criminal charges that is specifically defined in the Constitution. In Article 3, Section 3, Clause 1 of the Constitution, treason is defined as treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of two witnesses to the same overt act or on confession in open court. Well, number one, let's ask why the founders felt it was so important to include the crime of treason as being something that's defined in the Constitution. Well, the reason for that is that treason was overused by the British. Whenever somebody said something they disagreed with, and indeed, when there were many American revolutionaries who simply were making speeches, giving their opinion about the fact that the United States should separate from Britain, frequently these individuals were charged with treason, and oftentimes the penalties were very severe, including death, including the fact that their heirs could not inherit property from them. To be charged with treason by the British was actually relatively common among the Americans, and it was a fearsome threat to them. So like much of the Constitution, the treason clause is actually a direct reaction to the experiences that the American colonists had with Britain. Much of the Constitution can be looked at within the context of we want to do things differently from how they were done when Britain was in charge over here. That's why, for example, as another example, bankruptcy is specifically included in the Constitution. Well, the British, as we may recall from having read our Dickens in high school, included debtor's prison. Something that always struck me as incredibly counterproductive. I mean, how helpful is it to put someone in prison and then expect them to pay you back your debts? Somehow that doesn't seem to make sense. But the British would do that. And ironically, just giving an idea of how much family members cared about each other, it would actually work, because family members would then go to the trouble to raise the money to get you out of prison. The Americans, though, weren't so keen on having debtor's prison. So as a result of that, we specifically said that bankruptcy was going to be something that was going to exist in the United States and that we were not going to have debtor's prison. There are other examples of that. For example, the Fifth Amendment to the Constitution, part of the Bill of Rights, which specifically protects individuals from having to testify against themselves, was in direct reaction to the British, what they call star chambers, where essentially individuals would be brought into a room and questioned until essentially prosecutors could find a crime to charge them with. Well, the Americans said, no way, you should not have to assist prosecutors in finding something to charge you with. Thus came the Fifth Amendment. So again, many of the parts of the Constitution are directly related to our experience with the British. And in fact, arguably, the entire construction of the Constitution is in direct response to the British experience. The Constitution itself is quite explicitly designed to limit the power of the federal government and to retain power to the individual states. This was because we did not want to have, once again, some overwhelming central government come and tell the colonies what to do. So the entire Constitution, in many respects, was a direct reaction to our experience as colonists under the British rule. So within that context, the fact that they would include a treason definition in the Constitution is quite clear. What's more is that the founders made it clear that Congress can't kind of get around this part of the Constitution by simply defining another crime as something else, but that really is treason. So you can't simply say, oh, these acts that seem treasonous, we're just not going to call them treason and charge someone with this different crime. What matters is what the people are charged with. So you can't kind of get around this provision by simply calling it something different. Now, there are some other elements, actually, that are quite interesting about this clause. One, for example, is how they define the states. For example, it says, treason against the United States shall consist only in levying war against them. Again, showing the fact that the early founders of the United States considered the United States a collection of separate entities, essentially separate countries, really, who were working together to essentially combine their forces on a couple specific things, namely commerce and foreign policy. Outside of that, the Constitution was quite explicit about the fact that the states couldn't have their powers limited by the federal government the way they had been by the king. So you really see this idea of the states being a collection of separate entities rather than how we view them now as being one large country, which is really something that changed about the time of the Civil War. Next, they specifically say the things that you have to do to be convicted of treason. Number one, you need to levy war against the United States, or you need to adhere to their enemies, giving them aid and comfort. So you need to actually give aid and comfort to the enemies, or you need to make war against the United States. What's more is that the clause specifically says that there needs to be overt acts. It's not enough to think that you want to levy war against the United States. It's not enough to think that you wish that the Americans' enemies will fight against them. It's not even enough to say that. You actually have to take some specific steps, some specific actions, which are going to essentially levy war against the United States or give aid and comfort to the enemy. Finally, there's an evidentiary standard which is required under this clause. We often hear about how criminals are sometimes convicted based upon circumstantial cases. Well, you can't do that with treason. You can't even use forensic evidence. No, the clause is quite clear about what you need. You need either two witnesses to testify to the same overt act. So it can't be two witnesses, one testifying to one overt act, one testifying to another overt act. They need to be two witnesses testifying to the same overt act, or it can be based upon a confession of the individual, and that confession has to be in open court. It can't be a confession, for example, that was drawn out of someone by police during interrogation. It has to be a confession that's freely given by the defendant in open court. The Constitution is quite clear about that. And again, you can see where these provisions are really efforts to try to limit the power of government to invade the private lives of individuals, who the founders thought had really been kind of manhandled by the British. Now, subsequent Supreme Court decisions have added a little bit of context to this clause, making it very clear that this clause is to be interpreted narrowly. For example, in 1807, the court took up the case Ex parte Bowman and Swartout. Now, you may not recognize those two names, but the name who they were working for you may recognize. That would be Vice President Aaron Burr, the person who shot Alexander Hamilton in a duel. Aaron Burr is probably second only to Benedict Arnold as being one of the most treasonous individuals in the United States history. Frustrated with the fact that he was not made president of the United States, after shooting Alexander Hamilton to death, he then went and developed a plot to try to overthrow the United States and take over New Orleans. Bowman and Swartout were two friends of his who assisted him in that effort. They were caught, charged with treason, and the case made its way up to the U.S. Supreme Court, which dismissed those charges. Why did it dismiss those charges? Well, because of the fact that they might have planned to wage war against the United States. They might have started preparations to wage war against the United States. They might have even conspired to wage war against the United States. But according to the Constitution, that's not enough. You need to actually wage war against the United States. So for treason to occur, you need to actually wage war against the United States. Simply preparing, talking about, planning, doing any of those things is not enough. More recently, there was the case Kramer v. United States, where an individual was charged with assisting German soldiers in World War II who had surreptitiously come into the United States. It seems like this would be exactly the type of thing that was in mind when the framers talked about giving aid and comfort to the enemy, isn't it? Well, again, the court narrowed that interpretation, stating that concrete action of helping the enemy is not enough. You need to actually have intended to betray the nation to be charged with treason. In essence, what the court was relying on here is the part of the clause that says adhering to their enemies. Essentially, you might engage, for example, in war profiteering, something that helps the enemy, that hurts the United States, but unless you are quite specific about the fact that you intend to betray the United States, that's not enough according to the court. It's worthy of note, by the way, that this clause explicitly excluded language that is included in the British version of treason, which includes compassing or imagining the death of our Lord the King. No, the United States did not want treason to mean that you didn't like somebody who is our leader, or that you disagreed with somebody who is our leader, or even that you opposed someone who's our leader. Treason needs to be an act of betrayal to the United States as a whole. In other words, the founding fathers were quite clear about the fact that they did not want this to turn into some kind of political football that could be used to undermine political opponents, much like what it has become today. Well, if you agree with me or disagree with me, or have any other questions about the Constitution or the definition of treason, I'd love to see your comments down below. And if you could like this video and subscribe to this channel, that'd be a huge help. I'll see you in the next video. In the meantime, let's hope for continued progress. Thank you.